Oh, boy. Young Thug look a lot better since he ain't no more drugs. His dimples now, he don't got fat. All them not looking boys in there. Just this him gonna really change them. That's a good attorney right there. He's a good one. When he's zoned out, you better stay focused, brother. Snap out of it.
Under Iowa versus the state, or pursuant to Iowa versus state decision by the Supreme Court of Georgia and its progeny going forward, decided February the 5th of 1993. It's still our seminal case in Georgia in regards to. Of course, a trial court may release a person at risk of flight from the jurisdiction of the court or failing to appear in court or any person to the community or property in the community. 3 poses no significant risk of intimidating witnesses or otherwise obstruction the administration of justice, and that's OCGA. It requires the trial court to explain its reasons for the grant of denial of bond to assist in appellate review. That's Lane at 247 Georgia 389. The grant of denial of bail will not be set aside unless there's a manifest infringement or abuse of discretion, and that's a very old case, Jernigan versus the state, 118 Georgia 307 pinpoint 308 1903. Iowa requires, and we all know this, and this has been stated in earlier hearings, that the defendant has the burden of coming forward initially with evidence to show that he or she possesses, I should say, no significant risk of fleeing, threatening the community, committing another crime, or intimidating witness. This burden of production means that the person charged with murder must present evidence in the bond hearing on the factors that indicate risks in the community, which Mr. Williams has done on prior occasions. These factors include include the defendant's length and character of the residence in the community, employment status and history, past history of responding to legal process, and prior criminal record. Court cites Lane 247, Georgia, at 388. Once the defendant meets the burden of production, the state may present evidence to rebut placing, and then the court goes on to say that this is proper to place a burden of production on the defendant. So at that point in time, once that occurs, to protect the presumption of innocence, Ayala goes on to say the state has the burden of persuasion in convincing the Superior Court that the defendant is not entitled to pretrial release. This requirement means the state has the burden of proving by preponderance of evidence that the trial court should deny bail either to secure the defendant's appearance in court or to protect the community. Depending on the quality of the defendant's evidence, the state may not need to present any evidence to carry its burden of persuasion. So I determined in this case that Mr. Williams has in fact met the preliminary standards to show that he has ties to the community and roots in the community. And I find that his employment status and history are sufficient. The thing that still troubles the court has been presented to the state by the state in this particular continued proffer is that one of the factors I'm supposed to consider is or decide is whether or not Mr. Williams poses significant risk of intimidation or threatening of witnesses in particular. His interviews with witnesses in this case, attributing Mr. Williams asking for permission to harm others, the court finds that would make him pose a significant risk to the community.
Oh, don't get no bun. Stop, careful. He tried, but I think it's best for him. I think it's best for him to stay on the now. You know, don't worry about trying to get out. Y'all like, share, and subscribe. I'm out of here. You go to the doctor. You're going to the doctor Saturday. They going to get in your ear. Come on, what is going on with my StreamYard? Why is it doing this? It won't end. Get the nose. I can't wait till you go. What is going on? It won't stop. It won't stop, couple. Come on, y'all. Give me my thing. Now I got to work. My StreamYard is absolutely messy.